Right. Well, good evening, everyone. My name is Monica Bejarano Egret, and I am the Senior Management Analyst for the Richmond Rent Program. Today, I will be conducting our community workshop titled Purchasing a Rental Property in Richmond. And before we get started, I wanted to just do a couple of technical things here just for your information. All questions will be addressed at the end of the presentation. Throughout the presentation, you may click on the Q&A button, which is there at the bottom of your screen. I will also do my best to provide important links on our website in the chat. So those of you who are just joining, I did provide the link to the PDF version of the presentation that I will be conducting today. And the last thing is there is a closed captioning option for those who would like that option to be available, and you may access it in your preferred language if it's not English. This PowerPoint presentation is being recorded and will be available on our workshop's webpage. And like I said, I've included the PDF version of this presentation in the chat for everyone to download and to keep as a reference. And also just for future reference, I'm also including the link to our workshop's webpage. Feel free to save this as a reference or favorites in your browsers. So for the recording, you will be able to access this on our website in the link in the chat. All right, so now let's get into it. So for today, the presentation, this is the agenda. We will go over the introduction of the rent program and the Richmond Rent Ordinance. Here, I will go over the basics of the services we provide and principles of the rent ordinance. I will go over the sale of a rental property, buying a rental in Richmond, the options of a buyout, owner move-in eviction, or Ellis Act eviction, and what's next or what to do when selling or buying a rental in Richmond. And lastly, an overview of important California state laws, especially civil codes that were recently amended at the beginning of the year. So our office is the Richmond Rent Program. Our office opened around January of 2017, where we administer the Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, also known as the Richmond Rent Ordinance. And the services we provide are listed on this slide here, and I'll just point out a few that are on there. We provide housing counseling on issues related to the Richmond Rent Ordinance, referrals to community legal organizations that we contract with. We administer the rent adjustment petition process, and this option applies to rent-controlled units only, and I'll expand on what that means later. We also conduct educational workshops such as this one. This year, we're testing out a variety of options with in-person, virtual, or pre-recorded workshops. Again, you can access the link here in the chat to see other workshops that we've had in the past. And we also have our services conduct billing and collection of the residential rental housing fee. So going now into what is the Richmond Rent Ordinance. I think this is really important to note that the ordinance went into effect November of 2016, and the Richmond Rent Ordinance established the following main principles, which are rent control, just cause for eviction protections, the rent adjustment petition process, and notice filing requirements. Most of Richmond's residential rental units are covered by the Richmond Rent Ordinance, but not all units are subject to both rent control and just cause for eviction protections. And I'll explain that next in the next slide on how that is. So on the slide, you see three different categories. The first, going from left to right, fully covered properties, partially covered properties, and fully exempt. Right underneath of these titles, you see that fully covered properties are rent control and just cause for eviction protections. This is most commonly multi-unit properties built with permits before February 1st of 1995. Going over to the middle section, you see partially covered properties, which are those that are under just cause for eviction protections only. And these are governmentally subsidized units, Section 8, LIHTC, also known as low-income housing tax credit properties. Properties with one dwelling unit on one parcel. So this is single-family homes or condominiums. And what we consider new construction. And new construction are those that are built with permits after February 1st of 1995. And I will go into this later in the overview of California state laws, but primarily the properties with one dwelling unit and the new construction are classified under the Costa-Hawkins Rental Housing Act. And so now going into the third section are those that are fully exempt. These are properties that are not under rent control or just cause for eviction protections. And these are cases where a landlord and tenant share a kitchen and or a bathroom, where there's a permitted accessory dwelling unit, or also known as the ADU, when it's added to a single family home where the main house, so the single family home, the main house, is owner occupied. And lastly, when there's a nonprofit home for the aged. And those of you that are joining just a little late, I just wanted to remind everyone that if you do have any questions, feel free to leave them into the Q&A box down at the bottom of your screen. I will address questions at the end of the presentation, and I will do my best to include links in the chat for everyone as a reference. So now going into the enrollment registration and the payment of the residential rental housing fee. So landlords of residential rental units located within the city of Richmond must enroll all the rental units with the rent program. And this is done by completing and filing a property enrollment form with the rent program. All rent-controlled tenancies must be registered, and a new tenancy form must be completed whenever there is a complete change in tenancy. And landlords may access the forms on our website, which is the link at the bottom of the slide, or available upon request by email at rent@ci.richmond.ca.us. And landlords may file their forms with the rent program by either in-person delivery, by mail, or email. And after a landlord has enrolled and or registered their rental units with the rent program, our staff will mail an invoice that includes the residential rental housing fees for each rental unit. And I think that's a really important note, is that our residential rental housing fees are applied to each rental unit, not just the property. So for example, if you have a duplex, fourplex, multi-unit property, you will be billed for each rental unit on that property. And lastly, the residential rental housing fee is not the only fee that applies to Richmond rentals. I also included in the slide the other applicable Richmond fees to residential rental properties, which are business license, residential rental inspection program fee, and the fire prevention fee. And these are all administered by separate departments. So I've included the phone numbers here on the slide as a reference. So you may inquire if you owe any fees, how do you activate your license or inspection fee or fire prevention fee, because and I do emphasize to contact them separately because each department does have their own processes. And it's possible that you may be exempt, and they also have their own exemptions. So I do encourage you to call them each separately. And so as a reference, again, I will include the webpage for enrollment and registration here at the bottom of the chat. So feel free to access it here. If you are a new landlord or have not registered your property, you may do so by accessing the forms online. I will add that the city of Richmond does have a new system that they're implementing. It's called IMS. And so we will no longer be using eTrackIt. So there may be some changes to the enrollment process, but in the meantime, you may submit a hard copy of the enrollment form or tenancy registration with our office, and we'll take care of it and process it on our end in the new system. Okay, now going on to the next. So, uh, we often get questions of, how am I considered a landlord under the rent ordinance, and what does that mean? So I decided to include this specific slide here where it defines landlord under the Richmond Rent Ordinance as an owner, lessor, sublessor, or any other person entitled to receive rent for the use and occupancy of any rental unit or an agent, representative, or successor of any of the foregoing. So if you are defined under this definition for landlords under the rent ordinance, then you are required to enroll and register and pay the rental housing fee and go into compliance with the other departments here in the city of Richmond. All right, now let's get right into it. So for sale of a rental property, no landlord shall take action to terminate a tenancy without citing one of the just causes to evict. So those reasons I've included here on the right side for just cause for eviction protections. Those include non-payment of rent, breach of lease, nuisance, failure to give access, owner relative move-in, withdrawal from the rental market, also known as the Ellis Act, and temporarily vacate due to substantial repairs. And the last is temporary tenancy. You will note that there is certain requirements when citing a certain just cause, such as breach of lease, nuisance, and failure to give access. Those require written warning notices. Under owner or relative move-in, withdraw from the rental market or Ellis Act, and temporarily vacate due to substantial repairs, those require relocation payments. And I will go into more detail of these requirements later in this presentation. But in the 8 just causes that you see listed here on the screen, you will see that a sale of a rental property is not a just cause to evict. So in Richmond, when a property is sold, the terms of the tenancy will transfer to the new landlord. So as a reference, again, I've included a few links here on the presentation on the PDF version, which is available in the chat. These are clickable links. So if you would like to visit the rent program termination of tenancy webpage, you can do that here. Or if you'd like to access the written warning notice templates, they are available here at the bottom of the slide, as well as the 2025 permanent and temporary relocation payments are available on our fees webpage. So now let's go into California state laws that require lawful landlord entry. So when you're selling a rental unit, of course, that requires you to show it to prospective buyers. And so there is the state law, Civil Code 1954, where landlords may only enter to make necessary or agreed repairs, decorations, alterations, or improvements, and supply necessary or agreed services, or exhibit the dwelling unit to prospective or actual purchasers, or mortgagees, tenants, workers, or contractors, or to make an inspection under the California Civil Code 1950.5, which is the security deposit law. And so I've listed a few of those requirements on this slide. The main ones I would say are here, but I do recommend you can Google California Civil Code 1954. And so to highlight, the landlord must give the tenant written notice to enter at least 24 hours before entry. Landlord does not need to provide written or verbal notice to enter in cases of emergency. This is in a case of a fire or flooding, and the landlord needs to access the rental unit immediately. The tenant cannot demand that they be there when the landlord enters, and I'll explain that later. And entry must be during normal business hours, and these are normal business hours, whether they be 8 to 5, 9 to 4, whichever. Again, it's not specified in the law what normal business hours are, so you kind of have to take your best guess and just like generally those hours. Landlords must state the time and date as well as the purpose of the entry in the written notice to the tenant. And so, as I mentioned before, tenants cannot demand that they be there when landlord enters. And a tenant needs to be very careful when they are denying access to a landlord when the landlord is complying with this state law. because in Richmond, it is a just cause to evict when a tenant denies the landlord lawful entry after the tenant has been warned to cease denying lawful access and continues to do so. So in other words, this means that the landlord has provided 24-hour written notice to the tenant. On that notice, it provides the details as necessary under this law, and the tenant continues to deny them lawful entry after the tenant has denied them access. The landlord has provided them a written warning notice to cease, which standard it requires a minimum of 5 days for a warning for the tenant to comply. If after those standard 5 days, they do not allow entry under this state law, under our ordinance, landlords may proceed with an eviction under our just causes if they are to cite failure to give access. Okay. Now moving on. Tenant estoppel certificates. So commonly, tenant estoppel certificates are used in real estate transactions involving the sale or refinancing of rental properties. And once a tenant completes an estoppel certificate, they are bound by the information provided, meaning they cannot later claim inconsistencies. And the tenant's role is in completing the certificate is to verify the accuracy of the information provided and sign the certificate confirming the stated details. The landlord's role in this is typically to request the tenant to complete the certificate as part of the real estate transaction. So I've included some almost, FAQ or Q&A here where I explain what is a tenant estoppel and are tenants required to verify and sign. I get this question a lot. And so the answer is that tenants are not obligated to sign estoppel certificates. However, if they do, then the document may be binding, where a landlord may enforce the agreement through court. And another very common question is, what options do I have if a tenant denies to verify and sign a tenant estoppel certificate? In this case, options may be limited. The landlord may submit a public records request, also known as a PRA, with the Richmond City Clerk's office. However, the information filed with the rent program may not include the information needed to verify details such as lease agreements, security deposits, or rent amounts, unless the rental unit is a fully covered property, meaning under rent control and just cause for eviction protections, and the landlord has filed a tenancy registration form. So our general recommendation is that landlords practice good record keeping. So if they sell the property, they may transfer the pertinent information regarding the tenancy to the new owner or prospective buyer. All right, now we're going into buying a rental property in Richmond. So this next slide, I need to emphasize it a lot, is that if you are a prospective buyer here in the city of Richmond and you know that the property that you're purchasing is a rental, check with the rent program before purchasing. Now, buying a rental property requires careful planning, including understanding California laws, the Richmond Rent Ordinance, researching the market, and budgeting for potential expenses such as property taxes, maintenance, property management fees, and applicable City of Richmond fees. Under enrollment and registration, when you are buying a rental property, you should contact the Richmond Rent Program office about the property's registration requirements and status before purchasing. New landlords are responsible for the outstanding debts of the prior owner, including outstanding registration fees. And a very common question in this end is, why is a new landlord held responsible for the previous year's rental housing fees? This is because the rental housing fee is assessed to the rental unit, not to the landlord. And the Richmond Rent Ordinance requires that all landlords pay the rental housing fee and defines landlords as including all successors of interest. So as I mentioned before, I provided the full definition of a landlord under the ordinance in the previous slides, but this is why that the fees are owed by the current landlord and how they are assessed to the property. So it is for that reason when a new landlord purchases a rental property and there are delinquent fees, their invoice will include the current fiscal year's rental housing fee plus previous outstanding fees, if applicable, if there are any. So that's why it's really important that when you are looking into purchasing a rental, you know what the status is and if the unit or the property may be delinquent in paying previous fees, may not have registered, may not have submitted enrollment. I think that's important to know. And you can contact us. Some information, I will emphasize, may need to go through a PRA or public records request. But some information we can let you know if you are looking into a property. And so after purchasing, and let's say that you've done your due diligence, you purchased the property, you are now to update the ownership information with the Richmond Rent Program as soon as possible. Our regulations require within 60 days to ensure that the record is updated for all mailing and information purposes. All right, so now going into buyout, owner relative move-in, or Ellis Act evictions. So for buyout agreements require careful consideration and compliance with legal requirements. Landlords may offer tenant voluntary buyout agreements before the sale of a property. However, the tenant is not obligated to accept this offer. And there currently is no buyout ordinance in the city of Richmond, so we do not administer these. We do get this question a lot, but we do not administer them. So that's why we generally let both parties, landlords and tenants, know to carefully look at these private agreements and that they are voluntary, and to make sure if there are any legal concerns to consult with an attorney. Okay, so now going into owner relative move-in or OMI eviction. This under the Richmond Rent Ordinance is when the landlord or owner may seek to recover possession of a rental unit in good faith for the use and occupancy as their primary residence by the landlord or the landlord's spouse, children, parents, or grandparents. And so I've highlighted some important notes here under an owner move-in, where an owner is considered an actual person who has at least 50% recorded ownership. So this is if the owner wants to occupy that unit as their primary residence, they must have at least 50% recorded ownership. An eviction for an owner move-in cannot occur if the same owner or chosen relative already lives in a unit on the property, or if a vacancy already exists on the property. And at all times, an owner can request a reasonable accommodation if the owner or chosen relative, meaning spouse, child, parent, or grandparent, is disabled and another unit is necessary to accommodate the person's disability. So an example I use is that if you have an upper and lower unit, but your lower unit is not is currently occupied by tenants, but you have a vacant upstairs unit. If you require reasonable accommodation to use that bottom unit, maybe it's wheelchair access, whichever it may be, those may be reasons that you can claim as reasonable accommodation to occupy that bottom unit. Owner relative move-in requirements is the person moving in shall move into the rental unit within 90 days after the tenant vacates and must occupy the unit as a primary residence for at least 36 consecutive months. The owner must pay 1/2 of the applicable relocation payment within 3 business days after the tenant has informed the owner in writing when the tenant plans to vacate the unit, and the remaining half is due within 3 business days after the tenant has vacated the unit. And so there are protections for seniors or disabled persons when it comes to owner move-in eviction. And in this case, if an owner may not evict through an owner relative move-in, if the tenant meets the following criteria, where the tenant has resided in the rental unit for at least 5 years, and is at least 62 years old, disabled, or is certified as being terminally ill by the tenant's treating physician. Now, those are protections for tenants, but an owner and or their relative may evict a tenant who is protected if the owner or chosen relative also meets the same criteria and no other units are available, meaning the criteria of being 62 years old, disabled, or is certified as being terminally ill by their treating physician. So landlords and agents are encouraged to contact the rent program and or seek legal advice before initiating the process to recover possession of a rental unit. And they can access all this information at the link at the bottom of the slide. Because for an owner relative move-in eviction, you want to make sure again that you plan accordingly and you gather all your information before moving with this process. And so, as I mentioned in the previous two slides, there are requirements where the landlord is to pay the first half of the relocation to the tenant within three business days, and then pay the second half within 3 days. These are the set 2025 permanent relocation payments to tenants for the owner relative move-in eviction. It is broken out by unit type, so studio, 1 bedroom, or two plus bedroom. There are base amounts and qualified tenant household amount. Base amounts, as you can see here, range between the studio between 4,300, 2+ bedroom is about 9,100. Qualified tenant household amount, this means, and the definition is specific down here, but very briefly, it's either a senior citizen, disabled, has at least one child under the age of 18 living in the household, or resides in a lower income household, as the term is defined in California health and safety codes, and all those codes are listed here at the bottom of the slide. And those amounts are a bit higher, with a studio at 4,900 and a 2+ bedroom is 2,500. And a question I get a lot is are these, can I pay a portion of it? Can I come into an agreement with the tenant? The answer to that is no. These amounts are set by the city council each calendar year. So by January 1st of each year, these amounts are set, and these are the requirements under the Richmond Relocation Ordinance. So if an owner does conduct an owner or relative move-in eviction, these payments are required under both the Richmond Rent Ordinance and the Richmond Relocation Ordinance. Okay, so now the third option here under the Ellis Act, which is the withdrawal from the rental market information. The Ellis Act is a California law and part of the Richmond Rent Ordinance, and that provides landlords with a legal way to go out of the rental market business. And a withdrawal from the rental market is not the same as selling the property, and this is why. The tenant must be served a written notice for withdrawal from the rental market, which is a termination of tenancy notice. The owner must give the tenant no less than 120 days for the tenant to vacate the property if there is no qualifying tenant who lives in the household. And the owner shall provide a written notice to each tenant on the property, notifying them of the withdrawal from the rental market. Tenants may be entitled to a 120-day notice unless they are a qualified tenant. At this point, a qualified tenant can be entitled to a 1-year notice if they are a senior, disabled, or at least one dependent minor child, or are considered a low-income household and have been residing in the unit for at least 1 year before the date of the delivery of the notice to withdraw from the rental market. And if the qualified tenant wants the 1-year entitlement within 60 days of the date of delivery of this notice, the qualified tenant must return to the owner a notice of entitlement to a 1-year notice. So again, the qualified tenant, if they are asserting these rights, they are required to respond and provide this information to the landlord that they are asking for that 1-year notice. Now, according to state and local law, landlords are subject to a variety of penalties in the event withdrawing from with the withdrawing accommodations are offered for rent within 2, 5, and 10 years from the date the unit was withdrawn. Now, this is different from a sale of a property because essentially an Ellis Act eviction originally was to convert either multi-unit apartment buildings into office spaces. And those units or that property or any property on that parcel is not going to be rented for at least 10 years or planned to be rented for at least 10 years. And this is inherited by any new purchaser or new landlord of that property. So if an owner does an Ellis Act eviction on that unit or property and they sell it, and it's only 5 years in of an Ellis Act eviction, that new owner or that new landlord may not rent out the property for up to 10 years, as the consequence is possible penalties by state and local law. We do have, in this process, I would say is a bit complicated and does require a lot of attention. So we do have a step-by-step guide available on our website. But again, if landlords and or agents are curious about this process, they may contact us so we can go through the step-by-step guide, mostly on the side of requirements, notice requirements. But you may want to seek legal advice before initiating the process to withdraw the units from the rental market. In this slide, there are separate relocation payments. So for an Ellis Act eviction, it does require permanent relocation, which are separated by studio, 1 bedroom, 2+ bedroom. And same as before, base amount and qualified tenant household amounts. Base amounts range from $8,700 for a studio, 2+ bedroom at $18,200. For qualified tenant household amounts, it is a bit higher with $10,000 for a studio and $21,000 for a 2+ bedroom. Qualified tenant household amounts are defined here at the bottom of this slide. All right, so now what to do? And this is essentially a checklist to make sure to just to capture everything that I've gone over thus far. The first thing is prospective buyers should request property information such as tenancy registration, outstanding fees, penalties, and pending hearings. And the buyer should also ensure that the prior owner transfers the tenant's security deposits to them, or be aware that the new buyer is responsible for returning these deposits as required by state and local law. The second is new landlords should contact the rent program to fulfill the requirements to update their property enrollment regarding new ownership and change in a unit status, even if the unit will no longer be rented. This may lead to a request for administrative determination of inapplicability. Owners may access the forms to claim the unit is not available for rent, rent-free, or owner-occupied, or fully exempt from the rent ordinance by visiting our website, which is available at claim and exempt or inapplicable status, which is here on the slide. The third is make sure prospective buyers are aware of the residential rental housing fee because they may be responsible for outstanding fees or penalties that have not been paid by the landlord. And why, again, just as a reminder, the rental housing fee is assessed to a rental unit, not the landlord. And the rent ordinance requires that all landlords pay the rental housing fee and defines landlords as including successors of interest. The second part of that, I wanted to mention that the rent program's fiscal year is from July 1st to June 30th of each year. So the rent program staff mails all invoices between July and August of each year. And when invoices are unpaid, we send a following mailing to all landlords, notifying them of their unpaid fees. Thereafter, we send those unpaid fees to collections if they do not pay those fees within a certain requirement under our ordinance and regulations. And lastly, call the rent program. I always say, when in doubt, call us. and we're here to help. We're here to break down the information and help you along the way and assist you any way we possibly can, because as we know, this is a lot of information to have, and so we try to break it down so it's understood by everyone. And just as a quick reminder, a sale or foreclosure of a property is not a just cause to evict current tenants in the city of Richmond. Tenants have a right to remain in the rental unit unless the landlord has a just cause to evict. Tenants in properties under foreclosure or sale do not have to accept cash for key, or also known as buyout agreements or other incentive offers. Okay. Now going into the overview of important California laws. Actually, I'm going to pause very quickly. I see that some folks may have joined a little late, which is fine. I am including another link of the PDF version of this presentation in the chat, just in case for those who joined a little later and need access to it. Okay, so going first, I mentioned earlier in the presentation that those that we consider partially covered under the Rent Ordinance, meaning that they're governmentally subsidized, Section 8, low-income housing tax credit units, or LIHTC. New construction, so those that were constructed and permitted after February 1st of 1995, and single-family homes and condos are partially covered, meaning they're not under rent control, but they are under just cause for eviction protections. This is due to a California state law, Civil Code 1954.50, which is the Costa-Hawkins Rental Housing Act. The Costa-Hawkins Rental Housing Act is a California state law that was passed in 1995, which limits local government's ability to impose rent control on certain types of residential units. And specifically, it prohibits rent control on single-family homes, condominiums, and newly constructed apartment units built after February 1st of 1995. It's also important to note that another component or provision of the Costa-Hawkins Rental Housing Act is vacancy decontrol, where landlords may reset the initial rental rate for a vacant unit at market value. Once the initial rent is established, this forms the basis for all future rent levels. And for more information, and again, this is for new resetting, we call it just resetting the rent, and you are under a rent-controlled property, you can access the information regarding maximum allowable rent, rent calculations, and rent adjustments by visiting our rent increase webpage, which is the link is available here at the bottom. Sorry, I jumped ahead a little bit there. Oops. Sorry about that, everyone. Not sure what happened. There we go. All right, sorry about that. So yeah, the link is available under our rent increase webpage here. There we go. All right, so now going into California State Code 1950.5, which is the security deposit law. And generally, I'm not going to go into it in too much detail, but just to define what is considered a security deposit, I think is important. And this is any payment, fee, deposit, or charge imposed at the beginning of the tenancy as an advance payment of rent, or to be used for recovering rental defaults, repairing damages caused by the tenant, or cleaning. This does not include an application or screening fee. And the first month's rent isn't considered a security deposit, but money paid in excess of the first month's rent, including what is called last month's rent, is considered part of the deposit. And I'm going to point out a really important note because there was an amendment to this California Civil Code. There was an Assembly Bill 12, which took effect on July 1st of 2024, where it limits a landlord from demanding or receiving a security deposit more than 1 month's rent, in addition to any rent for the first month paid on or before initial occupancy, regardless of whether the unit is furnished or unfurnished. But there is an exception for landlords, and generally this is for what we would call, small landlords, where natural persons or limited liability companies, where all members are natural persons, and who own no more than 2 rental properties with a total of 4 dwelling units available for rent may still charge up to 2 months' rent as a security deposit. So if you are a landlord and you own no more than 2 rental properties with a total of 4 dwelling units available for rent, you may charge up to the double the rent for the security deposit. And again, this is at the initial of the occupancy or the initiation of that tenancy. A landlord can deduct from the security deposit to cover rent defaults when it's necessary, reasonably necessary to do that, repair damages that a tenant or a tenant's guest may have caused, and to do necessary cleaning. And this necessary is very important. Necessary cleaning is generally defined as needing to return the rental unit to the same level of cleanliness as it was at the beginning of the tenancy. And if allowed by the lease, so you want to refer to your lease agreement, to cover the cost of restoring or replacing personal property, including keys or furniture, excluding ordinary wear and tear. So tenants who have lived there for a very long time, it's very possible just naturally that there's just normal wear and tear, but anything beyond that that may have been caused by a tenant or tenant's guest may be considered to deduct from a security deposit. In this slide, we are going to continue with security deposit laws, as there has been quite a few changes to the civil code, and I think it's really important. In this slide, again, I'm not going to go through everything in detail, but when does the security deposit have to be returned to the tenant? This is within 21 days when the tenant leaves or vacates the unit. The landlord must furnish the tenant with a written statement, itemized amount of and purpose for any deductions from the security deposit, and return any remaining portion of the deposit to the tenant. So that's really important. There's only 21 days for the landlord to either furnish the tenant with a written statement when they're deducting from the security deposit and return any remaining portion of that deposit to the tenant. Where several roommates live together, another common question I get is where there are roommates together and have paid a deposit together, the landlord is not required to return the deposit until the unit is returned to the landlord vacant. So if those roommates all collectively came together and paid a deposit, but there may be one of those roommates still living there, the landlord is not required to return the deposit unless the entire unit is completely empty. If more than $125 are deducted from that deposit for cleaning and repairs together, the landlord must attach the itemized statement copies of documents showing the landlord's charges and costs to clean and repair the unit. And effect of sale on deposit. So when there is a sale of a property and the tenant, the landlord has the tenant's security deposit, here are the options that a landlord can do when they're selling. They may transfer the deposit to the new landlords or return the deposit to the tenant. So if the deposit is returned to the tenant and the new landlord can essentially come into an agreement of what that deposit shall be, and or the tenant can provide that security deposit directly to that new landlord. The tenant's recourse that if the deposit is not returned within the 21 days, they may make a claim or dispute the amount that the landlord is deducting. They may go to small claims court. Small claims, of course, is only for those amounts that are less than $10,000, and the tenant may claim up to twice the amount of the deposit for the bad faith retention. So it's really important to make sure you inquire with us about security deposits and what either party, landlord or tenant, need to do. There's also an important provision here on amendments to California Civil Code 1950.5, where effective January 1st of 2025, landlords must provide proof that necessary repairs were completed. and tenancies that begin on or after July 1st of 2025, a landlord must photograph the unit immediately before or at the start of the tenancy. I think that's an important one there. All right, so now we're going into Civil Code 1950.6. This is rental application fees. There was an amendment to this civil code that went into effect January 1st of 2025. This is Assembly Bill 2493 that amended Civil Code 1950.6 in various ways. And this is just what's on here on this slide. There's actually a much larger list of changes under this civil code, but I just highlighted a few. So it's not limited to this list. Landlords can no longer charge an applicant or screening fee if there's no available rental unit. Prohibits charging a prospective tenant a screening fee unless the landlord either A, returns the screening fee to any applicant not selected, or B, has a screening fee policy where they review applications in the order received. The first qualified applicant gets the unit, and they do not charge the screening fees to any applicant who the landlord does not consider. If you would like to access the California Civil Code 1950.6 and read through it on your own, you can access the link here at the bottom of the slide. Again, in a PDF file, it is a clickable link, so you can go directly to it if you'd like. All right, next is the California Code of Civil Procedure 1161 and 1170, which is the extension of an unlawful detainer. Effective beginning of this year, January 1st, it extends a tenant's time to file an answer to an eviction lawsuit from 5 court days to 10 court days. Also, change the timeline for the court to hear various months in an eviction lawsuit. The next is Civil Code 1946.1, which is the proper notice for certain termination notices. For most no-fault evictions, meaning under our just causes, our owner move-in, withdraw from the rental market, vacate due to substantial repairs, landlord must give at least 30 days written notice to terminate a tenancy if the tenancy is less than 1 year. Under this same code, a tenant must give a 30-day written notice to vacate, meaning terminate their tenancy, and can give notice on any day of the month. Once the lease has converted to a month-to-month lease, a landlord can, with limitations, require more than 30 days notice if the tenant is on a fixed term lease when they're giving notice to vacate. Under this same civil code, a landlord must give at least 60 days written notice to terminate a tenancy if the tenant has lasted a year or more. Please note that any termination notice served in the city of Richmond must cite one of the permitted just causes for eviction unless the rental unit is fully exempt from the rent ordinance. So again, if you're either fully covered under the rent ordinance or partially covered, you are required to cite a just cause, and there are noticing requirements when serving a notice to terminate a tenancy. The landlord must file a copy with the rent program within 2 business days after serving the tenant. And those notices are accepted online. You can submit them through the online portal under termination of tenancy, or deliver them by mail or in-person delivery. We do not accept notices to terminate a tenancy by email, which includes 3-day notices to pay rent or quit, perform or quit. We may not accept them by email. And this is our last slide, which is proper notice for rent increases. This is Civil Code 827. And this is where a notice to increase the rent by 10% during any 12-month period or less requires a 30-day written notice to the tenant. A notice to increase rent more than 10% during any 12-month period requires a 90-day written notice. And this section, the 90-day requirement, became effective January 1st of 2020. Now, a reminder that if the rental unit is fully subject, so fully covered under the Richmond Rent Ordinance, landlords must submit a copy of the notice of rent increase within 10 days of issuing it to the tenant. And if you are under rent control and you are a landlord and your property is fully covered, you may access templates of the maximum allowable rent calculator, 30-day and 90-day templates on our website under rent increase. And I can provide, if those are some questions on where to find it, I understand our website can be a bit complicated to navigate. So if that is a question and you'd like me to include that link in the chat, I'm happy to do so. And that concludes our presentation today. So thank you, everyone. The presentation is available on our workshops webpage, which is available at the link here on the slide. And here, just as a placer, is our contact information. So if you have any questions, now is the time. We will have about 30 minutes set out for Q&A. If I will emphasize that if you have a question and it's specific to your case, I will not be able to answer it at this time. If you would like to have a housing counselor follow up with you, or if you would like to know if your question can be answered separately, feel free to email us. Our email is here at rent@ci.richmond.ca.us, and we will do our best to answer your questions that way as well. So with that said, I will go ahead and open it up for Q&A. So just give me one moment. Let's see. I see a question in the chat. Can you put the link in chat for this last presentation? I believe I did, but I'll do it one more time. Okay. And just as a reminder, all Q&A, please, or any questions you may have, please list them in the Q&A box. Also, feel free to, there is the option at the bottom of the webinar to raise your hand. So if you want to raise your hand and ask your question directly to me, I can do that as well. But I'll start first with those in the Q&A box. Let's see, I have a question here. If you have an exempt property, do you still have to register? If you are new construction or under construction, does the inspections include the fire inspection fees? Okay, so the two-part question there. I'll answer the first part. If you are an exempt property, meaning you're not a multi-unit property built before February 1st of 1995, actually what I will do is go back to that slide. See here. So if you fall under these exemptions here on the right, you are not required to register with us. So that means you don't have to submit an enrollment form, you don't need to submit a tenancy registration form, and you don't have to pay the residential rental housing fees. To the second part of your question, if you are new construction or under construction, does the inspections include the fire inspection fee? I'm not sure. You would need to contact the fire department and the residential rental inspections. Like I said, they also have their own exemptions under their department. Okay, so that. I see another question here. It says, on my block, there is a single family home, which after being sold, the new owner has subdivided the home into individual rental units. Is there a way to see if this property has been registered with the rent program? Currently in the system, there is not a way to see if they have registered. Information that we can provide. So if you give us the specific property address, not here, but separately, call us or send us an email, and we would be able to tell you if they have enrolled. With that information, that is the only information, unless you're an associated party, meaning if you're not a landlord, a tenant, or an authorized agent on the property, we can't give you much detail more than that. All right, next question. A house with 13 years old rented for more than 5 years. Why has to have annual inspections? Again, we don't administer the inspections here at the Richmond Rent Program. That would be under the Residential Rental Inspection Program. I'm actually happy to include their contact information here in the chat. So if you would like to contact them directly, you can definitely do that. Just give me one moment. It will take me just a second to find that for you. Sorry, it's taking a little bit longer than I anticipated. Okay. So I'm going to include their webpage so that if you are interested, as for short, their acronym is RRIP. That is the link to their website. And on their website, they also have methods to contact them. So if you have very specific questions regarding inspections, I do recommend contacting them directly. Okay, next question. Is a duplex considered a multi-unit building? It is. Duplex, referring to the slide here, if the duplex is permitted and built with permits before February 1st of 1995, then we would consider it as a fully covered property, which is under rent control and just cause for eviction protections. Okay. Next question, follow up to that same question about a new sale and a second unit. Does it at least need to be permitted, even if exempt from the rental laws? So let me see if about a new sale and a second unit, and does it at least need to be permitted? I'm not sure if I understand. Follow up to the same question about a new sale and a second unit. Does it at least need to be permitted, even if exempt from the rental laws? Well, generally under building and planning for accessory dwelling units to be habitable and to follow health and safety codes, units do need to be permitted and go through the permitting process and comply with those codes. So again, I can't really say yes or no. Oh, I see they are renting out the basement, not previously permitted as an ADU. If so, under our ordinance, any dwelling unit that is being rented, meaning that the tenants in the unit have access to housing services and they're paying rent, still requires under our ordinance for them to register, enroll, and pay the rental housing fee associated to that property. Hopefully that answers your question. If you'd like more information and or to kind of discuss more of the details that you may not be able to provide, I'm happy to, you can send us an email and we can discuss it. All right, more questions. Good. I love questions. So if an owner move in due to owner's hardship, for example, unemployment, still have to pay relocation payment to tenant. Yes. The Richmond Relocation Ordinance does specifically state that if any landlord at any time proceeds with an owner move-in or withdraw from the rental market, it immediately prompts or triggers the relocation payment to the tenant. If there's any disputes, because you believe that you have a claim that you shouldn't have to pay them, the remedy for that is to go to court, or you may consult with an attorney. Next question, do I need to register if I purchase a fixer-upper vacant property that had been vacant for a year? So if you, how do I say this? If you purchase a property that is vacant, it does not require you to register, only if that unit is occupied by tenants. So many situations actually is that that unit may have had rental history. Maybe that unit was rented before and you recently purchased this property, but when you purchased it, it was vacant and you're planning to fix it up, you want to do construction, and your plan may be to occupy that unit yourself as an owner, or you might rent it. Either one of those options, you should contact the rent program, because if you are planning to occupy that unit, we can provide you an administrative determination to claim owner occupancy. We'll review all your evidence and see if you as an owner are living there and you can support that. We will change the status that it's no longer rented. But if you are planning to rent it after you fix up the property, we generally recommend enroll and register once that tenancy starts. And again, once that tenancy starts, meaning the first date of their tenancy, you have 60 days to enroll with the rent program. Okay. What do you mean if there are permits before 1995 for it to be considered a multi-unit building? Can you clarify in regards to a duplex? Yeah, so the permits before 1995, meaning that there's a certificate of there's a certificate of occupancy before that was issued to that unit or property before February 1st of 1995. That would then classify that unit or that duplex to be fully covered under the ordinance. So specifically through the permitting process, the ultimate is to obtain the certificate of occupancy, and that the original residency in that dwelling unit was before February 1st of 1995 would be fully covered. Okay, next question. Must single-family homes landlord need to fill out the tenancy registration form? Good question. So no, if you are considered partially covered under the rent ordinance, so you're just under just cause for eviction protections, you are not required to complete the tenancy registration form. You are only required to complete the property enrollment form, which is just here. So again, just the property enrollment, not the tenancy registration, which is only for rent-controlled units. Oops. This thing is going all over the place. Sorry about that. Okay, next question. I only see, you go ahead and ask your question. I see you said, sorry, one more question. And you could take your time if you need to, type it out. Just checking the chat one more time. Oh, I'm sorry. I think I missed some questions here in the chat. So tenancy registration form, okay, I answered that question. Okay. Yeah, and while people are typing in their questions and into the chat or the Q&A, overall for this presentation, I think it's really important that landlords keep, good documentation, and that, you want to make sure that you keep accurate and complete records of the rental, meaning your lease agreements. If you increase the rent, you want to make sure you keep track of that. Each notice that you serve on the tenant and present with the rent program, you want to keep copies of that. So make sure that everything is together when you are, conducting your business with the rental and or considering to sell or purchase a property. Okay, oh, I see some more questions here. I plan on moving into one of the units in a duplex for retirement. Current tenant is elderly. Can I do an owner move-in? I will need more information on that one. I can't really answer it the way it is. And it's probably not the best to answer it right now. So I do recommend that you contact our office and we can have a housing counselor go into more detail and understanding what the situation is. Because if, tenant is elderly, we want to make sure, are they considered a senior citizen under state law or under the ordinance? And there's a lot of other qualifiers that we would need from you in order to say if an owner move-in is permitted. But in the meantime, glad you asked this question. We do have a webpage dedicated to owner move-in information. And if you are curious about the information and notices that you may need to present, I will happily provide it here in the chat. Okay, next question. Under California law, a single family is allowed one junior ADU, I believe that's what you mean by JDU, and part of the main house, such as a basement. Then a second ADU that can be detached. If you have two, then would the ADU then be subject to the rental registration, but not the ADU? Oh, sorry, last sentence said ADU. So to clarify, junior ADU, part of the family home exempt, but the ADU detached, subject to partial rule. This is a bit more complicated. So these are those specific questions that I was referring to at the beginning. If they are very specific and you're trying to get an answer that requires an analysis, I do recommend you contacting our office and speaking with a housing counselor so we can see what the status is of these units currently in our records, and that way we can refer to the ordinance in certain sections. So unfortunately for that question, I won't be able to answer it now, but please refer to our contact information at the end of the slide, and a housing counselor can assist you. Okay. Let's see, I'm going to check the Q&A here one more time. Okay. No questions there. If there are any questions, oh, I see there's one. There we go. If an owner swaps house with a tenant and tenant gets to live in a better house with the same rent and tenant is very happy, does it trigger relocation payment? Good question. So again, the Richmond Relocation Ordinance is enforced by our just cause for eviction provisions. So a just cause for eviction protections. So again, those are for non-payment of rent, breach of lease, nuisance, failure to give access, owner move-in, withdraw from the rental market, temporarily vacate due to substantial repairs, and temporary tenancy. Only under the three owner move-in, withdraw from rental market, and vacate due to substantial repairs does that trigger relocation payments. So if there's a private agreement that you may have with a tenant or a landlord and both parties agree, that's a bit outside of our scope. So I wouldn't necessarily be able to say if this triggers relocation payment because it does not sound like it is a just cause for eviction protection. How much is expected for relocation payments? How is it calculated? Good question. So on the slide, it depends on what the relocation or what the eviction is citing. So just for this presentation, for an owner move-in, relative move-in, these are the amounts, and hopefully you all can still see my slide, that show studio, 1 bedroom, 2 bedroom. There's a $4,355 amount for base amount, $6,700, $9,100 for a 2+ bedroom. And if you may have came in a bit late into the presentation, qualified tenant household amounts are listed here on the third column of this table. And those qualified tenant households are those who are a senior citizen, disabled, has at least one child under the age of 18, and that is living in the household, resides in a lower income household, as that term is defined under California health and safety codes, or is displaced due to an owner move-in and the tenant has a terminal disease, as the term is defined under California health and safety codes. The way that this is calculated is based on the consumer price index, which is listed here. Amounts shown are for the calendar year 2025 and shall be adjusted on January 1st of 2026, and these are based on the percentage change in the consumer price index. If you're curious about the actual calculation, feel free to send us an email. We do have a lot of reference points that we can provide to you just based on what the CPI is for that year. All right, so looks like we are at 6:09. I will allow, we can do 5 more minutes. If there are any questions, I'll give everyone, if no questions by say 6:11, I'll go ahead and conclude this presentation for today. Who governs Richmond or RIP, which is the Residential Rental Inspection Program, and that is the city. So that is under the Community Development Department. Why landlord has to pay all the fees? You want to be specific? Is this so I mean, I'll just answer that one generally. Landlord, as it's defined under the Richmond Rent Ordinance, is the successor of interest of the property. And so our ordinance specifically states that the landlord is responsible to pay the residential rental housing fee, which is approved by rent board and the city council. So that's just generally by law, how it's written, that landlords have to pay those fees. And is there a contact number for the city that governs RRIP? Yes, I can go ahead and drop that information into the chat. Just give me one moment. So again, the Residential Rental Inspection Program is governed by Community Development, which is under the Building Division. And I've included the general link here. So that should lead you to Community Development, their website and contact information. And you'll be able to navigate to where specifically and who you would like to contact. All right. Any other questions? I'll give until there's no questions by 6:14. I will conclude our presentation today. All right, I don't see any questions, but take your time if you need to type them. But just as a reminder, this is a recorded workshop, so it will take a couple days for our IT department to convert the file to upload into our website. So maybe by Friday, we will have it posted on our website. You will be prompted after this workshop where to find the information on our workshops page, whether it be the presentation as a PDF file or the recording. The presentation will be available in Spanish through a PDF file and also a recording. A recording will be posted by next week. So we'll make sure to announce that information to everyone through our listserv. Okay, I see another question. Need number that governs RIP. I do have. So the number that governs RRIP, again, is the community development. I hope that this does transfer over. They have it as a link. So community development is here. Doesn't look like their email transferred, but the phone number is listed there in the chat. All right, we still got another question. So this will be the last question I will take for today. The question I have here is, if I'm interested in purchasing a rental property, how can I make sure that it is in compliance and fees have been paid with the Richmond Rent Program prior to closing escrow? Great, great question. So this here can be answered. I believe it's here. So I mentioned that you should check with the rent program before purchasing the property, and we can provide details, again, very basic details of whether the property has been enrolled with the rent program and if there are outstanding fees. We can't go into more detail on that, but those are definitely questions that you can inquire with the landlord that you're interested in purchasing the property from. So some of those details are here, that before purchasing, check in with us and we can provide the information, just general information. But if you would like detailed information such as documents, or proof or evidence of any documents that may have been filed with us, that does require a public records request through the city clerk's office. If you are wondering how to do that, which is also a common question, there is a website where you can submit your request electronically. And I will provide that link in the chat. And again, this is if you would like to obtain documents that have been filed with the Richmond Rent Program. And this is for a public request electronically. Okay. Well, thank you, everyone. I appreciate all the questions. We're happy to continue these questions if you would like. I will go ahead and slide over to our last slide, that if you would like to contact our office or access the workshop recording by Friday, or even the presentation is available as a PDF on our workshops page. The link is here at the bottom. And I just want to thank everyone, and I hope you all enjoy the rest of your evening.